my name is Paul Horn. I am a California probate attorney. And today is a very important class. It's a class that I am sure you will find useful on a professional level and on a personal level. Why? Because there is this disease that haunts us all. You cannot escape it. It's called death. I love you all, but I'm not going to talk to you all one day, period, whether I like it or not, right? I'm going to die. And when I do die, how do I pass this house down to my son, my daughter? You're going to get a phone. You're going to get a phone call from the son, the daughter that says, hey, can you sell this house? What are you going to do when you get that call? Do you have some sort of roadmap how to handle that? Right now, when the seller call you and say, hey, sell my house, you're talking to the seller, right? You're talking to the seller. The seller's going to sign your listing agreement. It's coming. Baby boomers are going to begin to pass away. That particular baby boomer has 4 children. Which of the 4 is going to sign your listing agreement? Which one? Okay, so it's coming. So that's what this class is about. When we're done with this class, you should be able to roadmap out on a piece of napkin how to handle that phone call. My mom died. Please sell this house. Do you have a 1 minute, a 30-second roadmap of how you would handle that? On the screen, I drew up a roadmap for you on the screen of how to handle these transactions. Okay, so when you get that phone call, you're going to follow what's on this diagram. Take out your Kodak phone. This is a Kodak moment. Take a picture of what's on the screen. So let's walk through this screen together. You get that phone call from the son, the daughter. The first thing you're going to do is you're going to pull up the grand deed. You're going to call up your title rep. Hey, title rep. Hey, title rep. Would you please give me the grand deed to that house? When you get that grand deed, only 2 things is going to happen. There's a fork in the road. When you get that grand deed, it's going to show the house is either in a trust or it's not. That's it. That's the only 2 scenarios. The owner of the house who's in heaven is either going to show that that house is in a trust or not in a trust. And depending on the vesting of that house, it's going to dictate how you're going to move forward with your real estate transaction. If the house is in a trust, on the left-hand side are the diagram. On the left-hand side, if the house is in a trust. And how will you know the house is in a trust? Let's say Carolyn Smith passed away. You pull the grand deed, it's going to say the house is owned by Carolyn Smith, comma, trustee of the Carolyn Smith Living Trust. When you see that, no probate is necessary. You will have the successor trustee sign your listing agreement. Carolyn Smith, your client who died, has 4 children. Which of the 4 is going to sign? It's going to be the successor trustee. So how it works, guys, how it works is when you go get your trust drafted, the lawyer is going to say, okay, you have 4 children. What are the percentages to the 4? You say equal share. I love them equally. The lawyer is going to say, great. Which of the 4 are going to be in charge? Which of the 4 is going to sell? Which of the 4 is going to hire a realtor to sell that house? That individual is known as the successor trustee on your left-hand side, okay, on the screen. So the successor trustee signs your listing agreement. The son, the daughter says, yeah, I am the successor trustee. Well, how do you confirm that? How do you confirm that he or she is telling you the truth? How do you confirm that? Well, one way to confirm that is you are going to ask them for a copy of the trust. You're going to ask that son, that daughter, and says, okay, wonderful. Would you please give me a copy of the trust? That son, that daughter gives you a copy of the trust. The trust is going to say, who is the successor trustee? And where will that son, that daughter find a copy of the trust? Well, the trust is normally probably at home somewhere. It's normally in a binder like this, okay? They'll give you the binder. In the binder would be the trust. The trust says so-and-so is the successor trustee. You confirm that. You're going to eventually give that to title. And that successor trustee is going to sign your listing agreement. And you move forward with your real estate transaction. What happened if the children cannot find a copy of the trust? You pull the grant deed, the house is in the trust, you just cannot find a copy of the trust. Then what happened? The grant deed shows the trust is the owner, you just cannot find a copy of the trust. Now what? Now, it's going to be too bad, so sad, welcome to probate. You say, what? My mom had a trust to avoid probate. Now you want me to go to probate? What's wrong with you, Paul Horn? Wake up. That's legit. I feel your frustration. But how is title company, the issuer of good insurance, how are they supposed to know who's the legal individual to sign the house to the buyer? How? Okay. So without a copy of the trust, without the original, you're stuck. Too bad, so sad. Go to court, go to probate, get someone appointed to be able to sign that grant deed, to be able to sign your escrow paperwork. The first takeaway of the class: keep a copy of your trust. A copy is good enough. If you lose it, remember this legal terminology. Too bad, so sad. Okay? Any questions so far? Raise your hand and I will unmute you. Any questions so far? Just raise your hand and I will unmute you and you can ask your question. Okay. All right. Let us move on. Okay. So, and so normally when you go get your trust drafted, on the screen are the various document that's gonna be given to you. When you go see an estate planning attorney, they're going to draft the trust. A good trust is gonna say, hey, give it to my children. Hey, if my children gets divorced, the spouse gonna touch it. Hey, if I pass away, my spouse marry a gold digger, let's make sure that new spouse doesn't take everything from my children. That's a good trust. The accompanying separate legal documents can be known as the durable power of attorney. Okay. Many times when you're on your listing appointment, you're going to find a senior citizen who's incapacitated. Okay. That is a big deal these days. Let me tell you why. Baby boomers are getting up in age. And what you're going to find is going to be, it's going to be a big problem. You're going to find in statistic wise, what you're looking at is this. 1 out of every 9 individuals 65 years older has dementia or Alzheimer's. 1 in every 9. The way the silver tsunami is coming upon you. We're living longer due to medical and technology, which is great. But sometimes our mind are not going to be there, right? So when your seller has dementia, has Alzheimer's, what do you do? This is a very important point. The husband or wife wants to sell this house. Husband has dementia. What do? You're going to ask for the durable power of attorney. The durable power of attorney, it's going to say, when husband was fine, when he went and got his estate planning drafted, he's going to tell the lawyer, give me a durable power of attorney. My wife can sign my name if I'm incapacitated, dementia, Alzheimer's. My son, my daughter. Okay? You're going to encounter that. They're alive. But if they're incapacitated, ask for the durable power of attorney. And when you get that durable power of attorney, you should give it to your title company immediately. Why? Because your title company, right, is the gatekeeper. They're going to issue good title on your transaction. Let them read it to see if it's legit. What are they talking about, Paul, to see if it's legit? Oh my God. Do you know how many online durable power attorney, online legal services that are out there? So not all durable power attorney are created equal, right? It may be impaired. It may lack some sort of, all kinds of stuff. Any questions so far, guys? Yes, Lorraine. Let me see. Let's see. Can you raise your hand?
Okay, there. I just unmuted myself. Can you hear me?
That's perfect. Yes.
Okay, good. Now, what if, let's say you have an individual that gets dementia and her kids do the trust while she has dementia?
If you have dementia already,
yeah,
and you do not have a durable power of attorney in place, you're gonna have to go to court and seek conservatorship.
Got
it's
it.
a long, lengthy process, very expensive. Lorraine says to me, her client, the children says, forget that. Why don't I just have her sign this piece of paper, the durable power of attorney now? The only problem is she's thinking she's signing a birthday card for Lorraine because her mind is out. Oh, give me the birthday card. Let me sign it. This birthday card has 15 pages. Oh, what a wonderful birthday card. I'm signing. Too bad, so sad, too late. Okay, so yeah. So once you have dementia, once you have cognitive impairment, you're not able to sign the listing agreement or sign anything. Now, you're going to say to me, Paul, what's the big deal, dude? What's the big deal? What's the big deal? People have dementia all the time. What's the big deal? Here is the big deal. Here is the big deal that I'm going to show you. The big deal is this. The reason why I'm bringing this up to you The reason why we're talking about it is this. The reason why we're talking about it, let me see if I can get there. The reason why we're talking about it is this. If you are not careful, you can get roped in. You can get roped into what's known as, let me see if I can, let me see if I can do this. You can rope into this horrible situation. This horrible situation known as, let's see if I can do this, known as, and you do not want to be in this situation, you can get exposed to something known as elder abuse. What is elder abuse? I wasn't abusing anybody. The son was right there next to the mom. Mom signed the listening agreement. I sold a house and that one son took all the money. How is that my problem? I'm the good guy. I sold even above market. How is that my problem? It's your problem. When the other son comes in and says, you assisted in this transaction when mom had dementia, had Alzheimer's, and you pay. Why? Because the law is very explicit. If you assist, you assisted in getting that house sold. Now you're roped into financial elder abuse. Okay? Let me show you one example, a real case. Can you see my screen where it says Jorgensen versus Lampier? Yeah? A real case, 2023 case, an 80-year-old woman, widow, had a stroke. She owes $43,000 on her $800,000 house in Long Beach. She's a little behind because of medical bill. She asked, now she has a handyman. Her handyman referred her to his boss, who's a wealthy real estate investor. She asked him for a loan. She says, let me buy that house for you instead. The owner, 80 years old, says, you know what? Let's do this. Give my sister a life estate. I will give you this house. You take over everything, take over the loan and all that. Give my sister a life estate. Let her live there until she passes away. She signed the grant deed over to him. He immediately evicted her sister. A lawsuit happens. Here's the verdict. That house is $800,000, right? When the court was done with him, there's a judgment for $6 million on him. She had no dementia. She did not have any Alzheimer's. Elder abuse, double damage, and you pay her attorney's fees. So the house is worth $800,000, that was 1.6. Okay, be careful out there. We want to protect our senior. Okay, protect our senior, protect your license at the same time. All right. So the durable power of attorney is very important when someone's incapacitated. Any questions so far, guys? Just unmute yourself, I think, and you can speak. Any question, or you want to share any story in this, where you're facing seniors that might
I have a
dementia?
question.
Yeah, Naval, hi.
Hi. So if your parent is older and you're going to move them out of their home, is it better to sell the house before they pass away, or should you leave it in the trust and do it after?
Okay. So that takes us to the next teaching concept. Okay. So the question is, my mom and dad might need some money, or my mom doesn't want to live there anymore. They're gonna come live with me, go to a nursing facility. So the question becomes, what about selling this house? What are some sell this house? Good idea, bad idea. Well, let's talk about a tax concept that I want to share with you. It's a very powerful tax concept. Okay, it's a very powerful tax concept. It's known as a step-up in basis. So you are going to encounter. You're selling these houses for these baby boomers who pass away. You're selling it for the son, the daughter. Mom might have bought that house in Van Nuys for $200,000. You're selling it for 1.5 million, selling for $1 million, whatever the value is. Okay. If the house is in a trust and you sell it after mom passed, you sell it, meaning the house gets passed to the son or daughter, and you sell it, there's a full step up basis. Meaning that even though mom and dad bought that house for very cheap, when you sell that house, there will be no capital gain. Okay. So for you out there, when your client, the son, the daughter who inherit that house, if they inherit that house after mom died, you can sell it and there'll be no capital gain. So the best way to achieve this greatest tax break is to put the house in a trust, meaning do not grand deed this. Do not put their name on your grand deed to your house while you are alive, because if you do that, you do not get the step-up basis. If you put their name onto the grand deed, you die, they sell it, they're going to pay capital gain. You're going to make America great again by paying more taxes. Okay. Any questions so far on this tax concept?
Yes, I have a question.
Hi, Mary.
Hi, Paul. A lady added her son in 2020 to her property because she was going to have an extensive surgery and didn't have time to do a trust and still hasn't done it. But she wants to do it now. So she's afraid of a reassessment of taxes if she moves anything on her on her title. And someone told her to make sure to have it grant deeded back to her from the son before making any moves or doing a living trust. So can you give me some advice for her?
My advice is don't do it herself. Go see an estate planning attorney. Go see a specialist. Go see a specialist so they can make sure that under certain situation, Proposition 19 stays intact to keep the property tax the same. So have her go see a lawyer. Mary.
Okay.
Now, I want to cover something I think that's very important. Very, very important. If you do not have a trust, it goes to probate. Okay. The problem is this. If you use Medi-Cal, and you end up in probate, you have to pay Medi-Cal back. You use Medi-Cal because you don't have a trust. You die, it goes to probate. The probate court is going to ask the Department of Healthcare Services, California, how much did Carolyn Smith use during her lifetime for Medi-Cal? California says $200,000. The probate court's going to say, sell that house, pay back California $200,000 first, then your children can get the rest. Do you think that's a good thing for your client or yourself? No. right? So if you do not want to pay Medi-Cal back, get a trust. The question might be, you've been on Medi-Cal for 20 years. Can you still do this? I've been on Medi-Cal for 20 years. Can I do this? The answer is yes. Follow what I'm going to put on the screen. Number one, you've been on Medi-Cal for 20 years, right? Do this. Put the house in a living trust. Then you can die. Do it in that order. No, not funny. Do it in that order. Okay. Yeah. All right. Any questions so far, guys? All right. So.
Hello, hi, Paul. Yes, this is Yolanda. Hi.
Hey.
So I have a question regarding the living trust.
Yeah.
So you think which way will be better for the living trust? Point out the trustee. So for example, we have a family trustee, and so I and my husband are the owner of the properties. So we have a son. So you think my son will be the trustee, or we are the trustee, the owner of the property will be better? So which way? Thank you.
So when you go create a trust, while you and your husband are alive, so we put the house in the trust. While you and your husband are alive, you are both in charge. You are the initial trustee. Your husband died. You're the trustee. After you die, so you and your husband both die, it goes to your son. He will be the successor trustee. He will be the one that can go hire a realtor and sell this house.
Okay. So if I point my son as the trustee, when I sell or purchase property by using the family trustee, I think they're getting lots of trouble because every time so my son has to involve
No,
to the transaction.
Stop. We're not going to put your son on there. Your son only become involved after you both die.
Okay. So, so you can help us to build the family trustee, living trustee, or
yeah.
Okay.
Yeah, your son are not involved in your business.
Mm-hmm.
Your son only becomes in charge as a trustee after you and your husband die.
Oh, okay. So after the class, maybe we can, I can have your contact information, just make appointment someday and meet you in your office. And you can help us build the
All right,
living
good,
trust.
all right. Okay, good.
Thank
you. All right, good.
Thank you, Paul. Yeah.
Yeah. All right. Anybody else wants to?
I have a question, Paul. This is Sandy.
Hi.
Going back to your too bad, so sad story. If you're not able to find the trust and you created the trust for us, do you always maintain a copy of that trust? Or when you give the binder to your clients, are you done and you don't have a copy?
So the question that's being asked is, hey, Paul, you said earlier how important it is to have a copy of a trust. And Paul, you said that if the family created a trust but lost the trust, and you said too bad, so sad. Well, what too bad, so sad about that? Why can't they just call the lawyer? Yeah, you can call the lawyer, but once in a while, lawyer die too. Thank God these sharks die too, right? Thank God these lawyers die too, right? Yeah, we die just like you. And when we die, we might shut down our office. So yeah, you're right. I do have a copy. You're right.
I just got to keep you alive.
Yeah, but when you go these days, when you go and get your trust done, like for example, what I do is I give you two things. I give you the original ink signature and I give you electronic copy. The electronic copy is going to be a USB like this. You just plug into your computer, you email it to yourself or so forth. Okay? Yeah.
Thank you.
Okay. You are welcome. Yeah. All right.
Paul, I have a question.
Yes.
Yes, I'm not sure if you covered this. Can you cover how to create a listing in a trust as well as in a probate? Did you cover that? I was curious. In the MLS.
Yeah. So here, why don't we do this? So in a trust, there will be zip form. That is for a trust. Now, if you are in a probate, let me show you the forms that you need. If you are in a probate, you're going to use, so for example, for your listing, you're going to use the residential listing agreement. It's a CAR form. And you're going to use the probate advisory. Okay, so in your zip form, there are designated trust listing. And if you find yourself in the probate, you're listing residential listing agreement along with the probate advisory, probate listing addendum. Okay.
Okay, thank you.
Yeah. So on the purchase side, here, let us take a step back. Let us take let's go back to our Kodak moment. Okay. Kodak moment. So we covered, if the house is in a trust, what do you do? If the house is not in a trust, it has to go to probate. You're going to follow the diagram that's on the screen, this roadmap. You get the grandee, and if the house is under Carolyn Smith, it's going to have to go to probate. In a probate, Carolyn Smith has 4 children. In a probate, who is the individual that has the legal capacity to sign your listing agreement? It's going to be someone known as the personal representative. All probate falls into 2 categories: full authority probate, limited authority probate. 90% of all probates are full authority probate. If it's a full authority probate, you follow what I list for you, the roadmap. On the screen, it says full authority. The lawyer is going to start the case. The lawyer is going to get your son, it's going to get that daughter approved. The judge is going to sign a form called the order for probate, along with another form called letters. Once you have these 2 forms given to you by the probate attorney, you see, like on the right where it says order for probate, and right next to it, I have the word attorney, signifying to you that that form is given to you by the probate attorney. Probate takes at least a year to complete, but you can sell this house while the probate is active. Okay? And what you do is this: once the lawyer gives you these two legal documents, then you can sign your listing agreement. Then you can accept an offer, and you give that offer to the lawyer. The lawyer then generates the notice of proposed action. 15 days later, you can close escrow. So full authority, which should be 90% of all probate out there, you follow that diagram. Okay. So now, if you are in a full authority situation and you are at the closing table, oh, let me see. You're at the closing table. Here's what you want to do. Here's what you want to give to escrow. Oh, let's see here. Here's what you want to give to escrow. Let's see here. Let me show you the form. So if you find yourself in a probate, you have full authority, you're gonna do this. Before you can close escrow, if you have full authority, escrow is gonna need that checklist that's on the screen. A copy of the order for probate, a certified copy of letters, the notice of proposed action, a tax ID number of the estate. Okay, so this would be a good idea to take a picture of this as well too. This webinar is being recorded. I think you can go back to SRAR on demand and rewatch this. Okay.
Paul, can I ask a question?
Yes.
What determines limited authority? What's the difference?
The majority of the time, inexperienced probate attorney, they don't know how to overcome certain situation to be granted with full authority. So if you go with a very experienced probate attorney, you're going to get full authority for your client.
Got it. Thank you.
You don't want limited authority because a lot more work, a lot more delay in the transaction.
And that's when you need court confirmation, correct?
Yes.
Got it.
So when we look at that Kodak moment roadmap chart, if it's limited authority, you're going to follow this diagram. When you follow this roadmap, you're going to see that one of the steps is called petition for court confirmation. And that's when other people can show up to bid on that house. You don't want that because it's going to complicate the transaction that much more. Your buyer is going to say, okay, you accept me, you accept my offer. I've done my due diligence. I've spent the money. And now I have to put 10% down. And now I have to go to court confirmation where someone else can show up and take this house away from me after I've done all this work. Your buyer's not going to like it. And if there's enough buyer who does not like it, what happens to the price of the house is going to come down. Okay? Yeah. So keep this chart handy. What I'm going to do is this. Oh, let's see here. This is what I'm going to do. I'm going to give you a link. I'm going to give you a link. I'm going to give you a link to my website that's going to walk you through why this probate takes 1 year to complete. You know, it's going to walk you through the first 3 months of probate. What happened in the first 3 months of probate? Here, let me just put that link into the chat box while I'm showing it to you. So I just typed it in. If you click on that link, it will take you to the same screen you're seeing that I'm showing you right now. On the screen, there's going to be video. Probate takes 1 year to do. Probate happens in 3 phases. The first phase takes 3 months to do. There's a video that's going to explain in detail what happened the first 3 months. Month 4 to month 8 is when you get to close escrow. How to do that? That's the detail in phase 2 of probate. And then in phase 3, This is the last 9 month to 9/12. There's another video. So watch that video, watch these video. It's going to walk you through. It's going to walk you through and give you a much more detail. Okay. Any question, guys, so far?
Hey, Paul, I have a
Yes.
question. Oh, sorry.
Yeah. Yeah.
Go ahead.
Cyril, go ahead.
Okay, yeah, question for you. We have to wait for that person on the full authority situation. We have to wait for the letters to take the listing, or could it be done before if we're pretty sure it's going to be a
Yes.
person? Okay.
Yeah, you do. Yeah. And let me just show you. So in all probates, you gotta wait till letters and orders are issued. And let me just show you what those form looks like, okay? So in all probate, the personal representative, the son or daughter, would only have the power to sign your listing agreement once this form is issued. This is a form called Order for Probate, signed by the judge designating which child, which gets to be the personal representative. So this form, the lawyer will give to you, along with this other form called letters. Once you have these two forms, then the signature of the personal representative are valid. Before that, no one is in charge. But after these two forms comes out, then you have someone designated by the court to be in charge. Was there another question? I think we had a female voice earlier.
Yes. Hi, thank you, Paul.
Yeah.
This is Mary. Thank you. I have a lady who bought her grandfather's property because it had a reverse mortgage, and he's still alive. And her taxes, she was promised by a lender, no real estate agent was involved, that her taxes would stay the same. He paid like $67 a month. And now the taxes are 10 times because once the sale was completed, LA County reassessed the value because they made it an arm's length sale instead of a transfer from family to family, indirect inheritance. And the title rep that looked into it said because grandpa's still alive, it didn't go from grandfather to son to daughter. It became arm's length sale and she got the loan. So the lender handled it without an agent or a title rep, just recorded paperwork after the fact. So I tried to advise them, but I think they thought I was going to charge them fees and mom got the lawyer to take care of it. So I don't even know what kind of verbiage or language I could have used to, like you said, title is the gatekeeper of the property ownership, right?
Yeah. So property tax is a big deal. Okay, property tax is a big deal. When you talk about property tax, you're talking about Proposition 19 on the screen. Proposition 19. So far, we've said if mom died and you're selling that house for the daughter or son, no capital gain. If the son or daughter wants to keep that house after mom died, will that house get reassessed? Here's the rule. The rule is if it's mom's primary residence, that son or daughter has to move in after mom died. Then the property tax will stay the same. Okay? And the formula is assessed value plus $1 million. If you stay in that range, no property tax reassessment. All rental property gets reassessed. Okay, that's the new law. If there's a rental property, mom died, and that gets passed to the son, the daughter, the property tax will get reassessed on all rental property. Okay, so that's a little bit of information on Proposition 19. Okay. All right. Any questions so far? Okay. What I want to do for you is this, as a parting gift. As a parting gift. I cover a lot of information in the last, 50 minutes or so. Okay. What if you like, if you are a reader, if you like, you can do this. I wrote a very detailed book on everything that I have just talked about. Okay. This book you see on the screen, The Real Estate Agent Guide for Probate and Trust Sale in California. I sell it for $99, but because you're here, you can get it for free. All you have to do is click on, I have a promo code. You type in your name, your email address, and the code. Are you ready? The code is SRAR. How did I come up with SRAR? What does that even stand for? I have no idea. SRAR. You click download and just go to your email, and that's how you can get this for free without having to pay the $99. Okay.
So do we just go to your website and how do we?
Yeah. Here's what you're gonna do. Here's what you're gonna do. So I'm gonna put this link that you see. I'm gonna put that in the chat box. If you click on that link that I just put in the chat box, it will take you to what you see on the screen. Okay. And basically it's just paulhornlawfirm.com/ebook. That's the link. You click it, it'll take you to what you see on the screen. It gives you two options. Pay the $99. You say, screw you, Paul Horn, ain't paying for that. Then you click on, I have a free promo code. And you type in your information. Yeah. All right, guys. Did you enjoy this class? Yeah.
I have one last question.
Yes.
I have a situation where two adult children in their 20s lost both of their parents within 3 months this year. The house was not in a trust, but I spoke to who is probably going to be the personal representative. It looks like they might be behind in mortgage payments. So what happens if it's the property is in danger of going into default?
No problem. No problem at all. Let me explain. No problem at all. So the question is, hey, we find ourselves in a probate. Mom and dad just passed. Okay, mom and dad just passed. And there's a mortgage on the house, and the children are unable to pay for the mortgage. And obviously probate takes a long time. So the question is, hey, what happened to the arrearage, foreclosure, how do we handle that? Okay. All right. So what I want you to do, I want all of you to look at the screen. Here's another Kodak moment. The California probate process is 1 year. Okay, 1 year. The message is you don't have to wait until the probate is done. You do not have to wait 1 year for you to sell this house. After the lawyer starts the case, About 5 months later, you can close escrow. From the day the lawyer starts, 4 or 5 months later, you close escrow. You say, Paul, no good, no bueno. There's a trustee sale. There's a foreclosure, the arrearage. No problem. Whatever the arrearage is, it will just come out of escrow. Yeah, there'll be late fee, but I mean, if there's no money, there's no money. So your answer is not to worry. Start the probate. You close escrow in 4 to 5 months. The arrearage will get paid as part of escrow. Did that answer your question, ma'am?
Yes, thank you.
You're welcome. Okay.
Paul, quick question for you.
Yeah.
Besides, people that we know and also through attorney relationships, is there another way that we could get probate listings that you would recommend? Or
You can go to this one website called probatemoney.com. Probatemoney.com. It has all of the probate out there.
and
It's a database.
typically these I realize that a lot of people are that the listings are through relationships with attorneys. Is that for the most part or no?
Yeah, I mean, just like everything else, like for example, I'm doing this class, I'm not getting paid for it, but I enjoy it, right? And I give out good information, and in return, I might get some business from you. So I think in life, I mean, I'm not Mike Ferry. I'm not a marketing guy,
Yeah.
Yeah. But yeah, there are certain places like probatemoney.com is where you can get a list of all these probate cases.
Okay. These are all the cases that are going through the process, right?
Yes.
Okay.
Yeah. So guys, I'm glad you were here today. Everything you learn applied to you on a personal level. Even if you never took a listing involving a probate, everything I taught you today, share with you today, you can apply to yourself. Okay. So it's been my pleasure to be with you. Thank you so much.
Paul, can I ask one question?
Yes.
This is Kenneth Collins. I wanted to know, do you still sell your probate kit, your binder with your
So I have something better. I have that probatemoney.com website with it's got all the probate existing case out there in California. It's much more elaborate now. You can go to learnprobate.com, and that's gonna have like so many resources. So I do. Just go to learnprobate.com and you're gonna find a bunch of other stuff.
Okay.
Yeah.
Great.
So, all right, guys.
Thank you.
Thank you very much for being with me.
Thank you.
Thank you, Paul.
Until next time. And I want to give a shout out to Teresa at SRAR. She's terrific. She's the one that brought this class to you. So if you see Teresa, as SRAR, thank her if you like this class, guys. Thank you.